World Environment Day is celebrated annually on June 5th and encourages awareness and action for the protection of the environment. This year marks the 50th anniversary of the World Environment Day, which will focus on the solution to plastic pollution using the hashtag and slogan Beat Plastic Pollution. I hereby invite all the dignitaries to come upon this stage to inaugurate the seminar by lighting the lamp.
You're good.
I request the dignitaries to take their respective seats at the stage. Now I would request Principal Sir to present the auditorium to our speakers. I would now request people to present the token of appreciation to the dignitaries. Thank you, Speaker.
I'd like to reflect on the question why we have assembled here today. Mother Nature, Earth, Environment are all synonyms we use for the bigger circle, the master plan that surrounds us as we live and prosper on this miracle of a planet. Even though we proclaim ourselves to be the smartest beings on this sphere, we fail to recognize that we are a small part of the broader mechanism. bigger than what the finest engineer can build, or beyond anything the most talented poet had ever envisioned. It is the nature that gave us air, water, land, and minerals for us on a silver platter to thrive on. After all the global warming, pollution, and wastage that mankind have wreaked upon the world, one single day out of 365 days to commemorate and plan for the better future of our planet is the least we can possibly offer. Unfortunately today, due to some urgent obligations, Dhruvajyoti sir, our IPS member secretary of Kolkata Police Law Institute, is unable to join us. We'll proceed with the program now.
It is my pleasure to introduce our first speaker for today's seminar, Dr. Arup Poddar, Professor of Law at West Bengal National University of Calcutta. Dr. Poddar has done specialization in international environmental law from the North Bengal University. He has total 8 books under his possession, in which he edited 3 and authored 5 of them. He has done research work in the Water Resource Department on the draft model bill for the protection, conservation, management, and regulation of the groundwater resources. He is also the chief editor of 2 online international journals, International Journal of Law and Policy Review 2012 and International Journal of Legal Studies and Research 2012. Professor Poddar is the examiner of PhD theses of many universities, such as University of North Bengal, Banaras Hindu University, Sikkim University, and many more. He is also the member of Board of Secretaries of Amity University, Sikkim University, and JIS University. Dr. Poddar is the head of School of Technology, Law and Development. Professor Poddar is a permanent member of Academic Council at A.M.J. Sir, now I will request you to deliver your lecture on emerging trends on public doctrine.
ওখান থেকে আদিত্য দা আছে।
Very good morning on this Eco Day that is called World Environment Day, and I have been assigned with the topic of public trust doctrine to be disseminated in this particular August gathering. Now, obviously, this is not a class, a formal class there where we should, in fact, go ahead with the discussion, problem-based discussion, and question and answer. But at the same time, when we are speaking about like how to live our life, perhaps that makes a difference, not only for us as the present generation. Our lifestyle ultimately also would give different ambience towards the generation which are yet to come. We have known many important issues so far about the rights of unborn person, but this was not known to us that this also, the right can also be further taken to the future generation in terms of protecting the environmental rights. Well, the World Environment Day was never thought of. I'm like, when you speak about 1972 or prior to that, this concept was not at all available in this specific discussion so far. But let me come back. Why it was being given so much of weightage. And for India, now we are making UN try, like, you have to take a pledge for Environment Day. You have to not only take pledge on the Environment Day, but you have to fulfill your obligations throughout 365 days, so on and so forth. So let me come back with that aspect, like why it was so important, and thereafter I'll delve into the topic in today's discussion. So definitely with the permission of the principal and the other dignitaries on the dais. Let me start my discussion here. And at the same time, I don't know in fact, this discussion would be boring to you or not, but obviously if you feel it boring, definitely raise your hand. And at the same time, let me know why it is boring to you all. Right? So let me come back with your side discussion. That is something that's very important here. I'm like, when you are coming from your home towards this institution for attending this seminar, what are the important features or what are the important, the events that you have come across in today's traveling, which are exactly against the World Environment Day? Any one of you could show your hand and say like, okay, this is the incident which I found, which is absolutely not at par with the observation of World Environment Day. So, as I said, this is not a class. Obviously, it's a very informal discussion altogether. We are thinking in that particular perspective. So, some of you might be having, I think your voice is very loud. So, without mic, you can reach to me or reach to the other dignitaries at the same time on the dais. So, any one of you would like to take the participation, saying like, okay, what is not, in fact, as per your observations, which is to be met for the World Environment Day. So, many of you obviously have come across, but I'm not finding feel dare, law students of the first requirement is that you should be dare enough to take ventures in defining the facts, because once you define the facts, we have the advocate from the Calcutta High Court, so obviously Mr. Bihani. So he was also very much well associated with our NUJs earlier when Professor Nayan was associated with the NUJs. So, the law definitely suggests that when you narrate the fact, only you can apply the law. So, any one of you would like to raise hand and say that, okay, fine, this is not being found, or this is being found, something which is not incompatible with the World Environment Day. It's going exactly against the observation so far. Fine. So don't feel shy, right? Okay. So if you have, meanwhile, your question, or your observation, raise hand. I'll just give full opportunity to you to speak on that. What exactly is the observation of yours which is not at par with the World Environment Day so far when you're coming from the home to this institution? Well, so maybe when we are discussing in longer term, perhaps you might have some important inclinations towards saying that what are those features. The first ever, the international convention where the right to environment should be considered as a human right, for the first time, mentioned in Proclamation 1 of the Stockholm Declaration, but that was held long back in 1972. And you all know by this time, perhaps, okay, anyone can show the hand by the time you have already studied environment law. See, I'm not going to ask any questions, right? Just to understand, okay, how many of you are really conversant with the environment altogether? Any one of you, from the student side, I'm saying. No hands? Okay, not studied the environment law. That's quite surprising. So that means my vision is going to be absolutely extempore in this regard. All right. Okay, so I'm finding two hands are there. So definitely, see, I'm not going to ask any questions, so don't fear about that. Fine. But feel free to participate. What exactly are the events you have come across while coming from your home to the institution, which you can say better? These are exactly not compatible with the World Environment Day altogether, right? So I'll just ask one question maybe at the end of our discussion. Feel free by this time, right? Prepare exactly what is going to be your narration. Well, 1972 is the year when, if you go with the Michael Jackson, okay, all are paying attention now? Fine, very good. So, the Michael Jackson, in fact, had so many important songs. I'm not saying I'm bad, that was another important song, but he made a very important song in the Earth Day, right? So, everyone, if you're already knowing that. And, there was a slogan. The Michael Jackson came very late with his song, but became very popular subsequently. But the interesting part is that song ultimately was, a kind of a narration, a reflection of the slogan in 1973. One Earth, right? One Earth. So Earth song came from that. So when you go with the slogan of One Earth, that means obviously it is one Earth. We don't have, suppose you are having a problem with one home, you are moving to another home. So if you consider Earth as a one home, so obviously you can't move to another planet, right? So the Michael Jackson song has that very important implications you can watch in the YouTube videos altogether. So that one earth, this particular slogan came from 1973, and the same 1973 5th June was considered the first World Environment Day. So today is 2023, that means we are basically facilitating 50 years of World Environment Day. So when we are speaking about the 50 years of World Environment Day, and if you look back, because 1973, the particular seed that was shown in 1972, that is called the Human Environment, or United Nations Conference on the Human Environment, that is called Stockholm Declaration also, 1972. So the ultimately seed which was shown ultimately came up as a part of, so far this slogan of One Earth, and then became the 5th June 1973, the first observation of World Environment Day. If you look back to this, okay, if you are searching it from the Google also considered to be a teacher for us. Lots of information they provide, and nowadays we are finding lots of other informations through ChatGPT, right? Okay, so ChatGPT, you have another important options to go for. So finding out lots of informations there. Okay, so now coming back from these exclusive aspects of what exactly is the origin for the World Environment Day, we have today's topic here. And now this is a topic which I don't know how far is going to give you interest, but let me try to make it little bit problem based, and then coming with a solution. Public trust doctrine, right? So meanwhile, I think those who have already studied law, perhaps prepared about what are the incidents they have encountered today in coming, not compatible with the World Environment Day. So I'll give you the opportunity at the end, okay? I'll just call you here quickly to give your voice. Now, public trust doctrine. Remember, this is a doctrine which is quite interesting in terms of going with the legal fashion. I'm when we are speaking about the fashion means, different kind of doctrines or theses will be coming up, and the analysis will be given by different persons, different way. But ultimately the core issue remains same. Now what public trust doctrine so far means is about that there are certain properties where the government cannot claim ownership. Now what is called government ownership, like those who have studied the law of contract, they know what is the meaning of government contract, right? General contracts are anyway available, but there are certain implications of what is called government contract. There are huge differences in terms of when we speak about regarding the parameters to be fixed for government contract. So taking into account about that, this public trust doctrine suggests that the government cannot own certain properties. See, it says, point noted, certain properties. Now what are those? So coming back to that particular field, there are certain properties which we consider as, atmosphere, the complete stratosphere atmosphere cannot be owned. Similarly, when you speak about the forest land, seashore, coastal line, these are also not the property which the government can own. Wildlife, government cannot own. Now, the point is that, from our childhood, we have always understood government owns the property, government owns the forest, government owns the sea coast or coastal line. But that was a kind of myth that in reality, if you go ahead with the legal terms, you won't find any relevance with that. So the issue is quite interesting now here, and let us try to understand what exactly that means to us. Because the slides are available, I will also request the organizer to send this slide across to the students' body also, so they can also have this important issues. So this slide will go in its own pace. I'll discuss in my different particular perspectives so far. Now, when you're speaking about the public trust, what is this public trust doctrine so far means? You can see it in this slide. But as we say, public trust doctrine, you can't consider it was not available earlier, subsequently got added. It is not true. But the point is that when we are speaking in terms of the application, yes, in India, from which it started, that is my question. So those who have studied environmental law, perhaps by this time, if they have studied these Kamal Nath case, that is MC Mehta vs Kamal Nath case, perhaps they can answer that from which year this public trust doctrine came into operation in India. Now, when you go with this Kamal Nath case, if you read that Honorable Supreme Court judgment, you will find, the number of information is being gathered by the Supreme Court judges and then delivered the decision. It's ample clear that why Supreme Court had to go beyond the provisions of forest conservation in 1980. It's a major question, remember. Do you know from the Constitution which particular article says about to complete justice Supreme Court obviously can deliver awards? So it's Article 142. So we all know, right? So to do complete justice, remember this can't be applicable to high courts. Because if you do something as a high court judge, many of you are future judges here, so if you do that, ultimately the matter will go back with the Supreme Court and Supreme Court simply will struck down because high courts are not supposed to go beyond the provisions of law. But Supreme Court, yes, can. Provided that is qualified under which article? Article 142. So now public trust doctrine came in that era, like in India, when there was a need to protect and preserve environment. Now let me quickly come back with one other important option. When you see this slide, you will find like what is called PTT. Not going in detail because that will further make the boring session once more. But as soon as you go with the aspect of Indian so far the cases, remember there are sets of judgments where the Supreme Court has given weightage towards environmental preservation. There are sets of judgments, another round of judgments, where you find the judgments are dealing exclusively with preserving the larger projects, developmental projects, but at the cost of environmental preservation. Now, obviously, you can find out like why it is so. So that you have to take the help from the very important doctrine called sustainable development. So, sustainable development is the answer for that. There are certain projects which have to be undertaken. Why? It is a need of the hour. Because India can't compromise with its GDP, right? So to do that, what happens if you take these steps? Suppose the government of West Bengal and government of India take steps. Okay, we are just going to take 100% steps regarding protecting and preserving the environment. So no development then, because development depends on exploitation of natural resources. So, just to have a important aspect when you are finding in Justinian Code here, perhaps you know already by this time from the jurisprudential perspective why Justinian codes are so important. In particular when you go with the natural law theory and Sabinus theory both. But more than that, Justinian Code has another important implication, suggests that when you, as a nation, the owner of the nation, who is the owner of the nation here? The very important aspect is, in India, you'll find the people. That means constitution by the people, for the people, and of the people. So ultimately it is the public at large is the owner, right? So in that context, Justinian Code is very clear that there are properties, like for example, running river, running water. Now running water, where you find running water? Obviously in river. Are there any other examples where running water is available? Living apart, like ocean is actually storage of water, finally, right? But if you go with the running water, anywhere else apart from rivers, so maybe you will be thinking like, this question is absolutely not required. It's an unnecessary question because wherever you will find like, running water is only river, right? But now, going back to that, the Model Groundwater Bill of 2005, recently being updated in 2012. Running water also means groundwater, subterranean water. So the groundwater moves one place to another place through the help of aquifers. So running water is not only for the river, remember, running water is also applicable for the groundwater too. So as soon as you take running water, Justinian Code is applicable. But remember, in India, the legislatures did not think that the concept of public trust, where government is not the owner, public is the owner, and there should be restriction regarding the the use of such water. For example, if you are an owner of a particular piece of land, can you extract the groundwater as much as you need, or can you extract the groundwater for industrial need? That's a very important major question. If the example of groundwater is running water, then the extraction of the groundwater is also limited as soon as you apply public trust doctrine. Justinian Code is about that. See, as I said, like to make this session interesting, there are certain important issues we have to take into account. If you go with these theoretical aspects, for example, Roman law theory, yes, Roman law theory is the first ever aspect which came up regarding there are certain properties which belongs to everyone, there are certain properties which belongs to none. So that exactly being considered being so far devised of. So as we understand from the perspective, what are those properties which belongs to everyone? So as I said, like the river water. Do you know that any example of river in India where the ownership was given to an industry? If you consider river is absolutely public property, then the ownership should never be given in the hand of private owner, right? But in the name of an industry, a particular river was being so far earmarked. And I can give the hints. Government of Chhattisgarh. For the hints, the Sony brothers who own that property. Further hints, wild hints. Shivnath River. This is exactly his nomenclature is Shivnath River. And remember, Shivnath River in Chhattisgarh, basically, that was being given in the hand of Sony Industries for like coming up with the distilled water, which distilled waters are used for the like the batteries, secondary cells. So for that, the concerned industry was being given the ownership without considering that what is going to be the fate of that particular ownership. Now, as soon as the concerned Sony brothers they got the ownership, they immediately started so by extracting the river water at an extensive scale, by which the lower riparian villages, including cattle, got suffered. That was a blunder in our history, but that was taken away finally. So rivers are absolutely not the subject matter of private ownership. It's a public ownership. Now the question is that public ownership means what? Suppose we are the public in this hall. Can we go in the forest with our whims and fancies? Can we go to wildlife with our whims and fancies? The answer is no. To visit the when we speak about restricted forest, when we speak about regarding the sanctuaries, national parks, we as a public, though we are the owner, we can't visit the national parks and sanctuaries as per our own wish. Why? We are the public, we can do whatever. But remember, as a public, we have given the administration in the hand of government, who ultimately administers the entire country. So governments become a trustee, and basically we are the owner of the trust. So the government should act as a trustee. That's a very important aspect being specified here. So that means what happens as a public also, we have no such unbridled power to take or unbridled right to take entry in those particular public properties which are meant for public ownership. But that is exactly being so far suggested here. But now let me come back with another important option from this particular perspective. If we look back to the aspect of Professor Joseph L. Sachs, why I have given this name, Professor Sachs' name. So perhaps law students already, unlike the environmental law students, they already know this particular nomenclature. Professor Sachs, anybody would like to point out why his name is being taken? Remember, judges, I'm not sure about High Court. Perhaps Mr. Bihani will be further giving this ideas. But Supreme Court judges in India, you will wanted to know, the judges have taken reference from the articles before delivering judgment. Means when you develop a very high quality of article giving so much of references, which definitely has a very good resemblance with the present fact and law. So judges of the Supreme Court, they cite your article in their judgment. You won't find generally in high courts, but in Supreme Court, because of Article 142, these articles are referred by judges. So remember that you are brilliant minds. If you write such an article, judges cannot avoid, Supreme Court judges cannot avoid. Why I am saying so, there is a reason behind. Now, Professor Joseph L. Sachs is basically a professor in the University of Michigan. He's a professor only. But his like findings got quoted by the California Supreme Court. And remember the public trust doctrine, what we are finding now in India, basically, the Indian judges, they have copied it from the Supreme Court of California, from the monolith case, national ornament case, right? And why so? Because the fact is that Professor Sachs' opinion was so having integrity that to accept merely as a part of judgment will not give justification to the judges of the California Supreme Court that how come you know this theory. You have to give the origin behind, right? So then the Supreme Court judges, they have given the name that why we are accepting this article, Professor Joseph Sachs' article, that was very clear. And you will find like it was done in 1970s. 1970s, the era means obviously you can't find like, nowadays the Supreme Court judges also started quoting from different articles. Obviously having that stature, otherwise not possible. So what happened basically, the Professor Sachs got, after quoting this particular line by the Supreme Court of California, Professor Sachs was considered to be the propounder of modern public trust doctrine. So he dwelt into, rather he in fact made the origin of the modern public trust doctrine. Now why so? That is very important aspect of why it is so important from that particular perspective. So let me quickly come back with that approach. What exactly was the issue being considered? 3 restrictions. Professor Sachs provided 3 important restrictions, and what exactly are those restrictions we have to understand now. You can find out in the slides as well. Now here lies the crux. As environmental students, they already know what is called Forest Conservation Act, which year 1980, right? And as soon as you go back with the Indian Forest Act, which year? 1927. See, why we recall year of the particular enactment legislation? Because it has a very good repercussion with the further development and previous developments. Obviously, we have to always keep in mind that which year particular act got enacted. It has a very good resemblance with the further development. So 1927 Act, we consider that was a systematic exploitation of the forest resources in India, because that was being enacted by which parliament? British Parliament, 1927. But as soon as you receive that forest conservation in 1980, you definitely arrive to a conclusion that since the conservation is in the bracket, means you're giving more emphasis in the legislation regarding conservation of forest resources, a part of natural resources. Like wildlife in the bracket, like Conservation or Protection Act, like Water Act, you find in the bracket, Prevention and Control of Pollution Act. So that bracket means it gives, as per iOS, Independent Statutes, giving more emphasis, or a particular statute is made for that particular purpose, right? That is the meaning. Now the restrictions are here. Why I say that it's a crux of the issue, because in this aspect we could find out that the Forest Conservation 1980, Section 2, if you go with that, and Clause 2 and 3. Section 2, Clause 2 and 3. Now, there is a major role being played. So it was being given in the hand of the government, state government, that the state government can alienate a private corporation or company. Now what is called purpose, what is called non-forest purposes is very clear from the term of conservation. But state government can do that, and to take the effect of such notification, state government will have to take a prior, say post facto approval and prior approval. Here it gives the indication prior approval from the central government. So it's quite clear now. Now this exactly is the indication which will come back, that the 3 restrictions. So remember, there is a law. There is a law which authorizes the state government to alienate the forest land or transfer the forest land for non-forest purpose in the hand of private owner. Now if you take on the one hand public trust doctrine, which says forest lands are belonging to public, private individuals cannot own that. So how come Forest Conservation Act 1980 giving such particular liberty? So there was an interesting fact, and the same matter came before the Supreme Court in India, that is called the M.C. vs. Kamal Nath case. We'll come back to that quickly after some time. So the three restrictions are what? First is about the property subject to trust must only be used for the public purpose. So there is a specific issue what we call public purpose with general public purpose. Now, do you have, do you have any idea what is the difference between public versus general public? Obviously, these are very tricky terms, right? So environmental students perhaps can highlight on that. Even the contract law students also can highlight on that. What is the difference between public versus general public? Right, we'll come back to that subsequently. Second is that the property must not be sold in whatever the equivalent fair cash. That means it is not possible to be transferred. And third, the property, whatever the nature of the property, the nature must be maintained, protected, cannot be changed. So if it's a forest property, you can't transfer the property for non-forest purposes. These three are the restrictions which made the article developed by Professor Joseph Sachs very interesting, and that was being taken into account in public trust. So, any idea about public versus general public? Because that is very important here now. So, in India, we can take an example. Okay, you have lots of forest in India. For example, if you take the Kolkata National Park, it is in Rajasthan, right? And then the Gouranga National Park is under the periphery of the status of the Rajasthan government. But can you say that the particular forest which is Gouranga National Park located in Rajasthan is belonging only to the public of Rajasthan in India? You should say yes or no, but you must have justification for both the answers. So what happens here, when you are going with this particular, analysis, the properties as per the public trust doctrine, the concerned national park is belonging not only to the public of the Rajasthan but the entire India. So that means what happens, the difference between public versus general public. So state public versus the national public, national public becomes the example of general public example. Now why I am saying so, because there is an issue behind. Let me come back with that aspect. In 1983, when for the first time this monolith case got decided, you know what happens? Los Angeles city is, why it's so popular in America? Anybody to highlight? So obviously it's basically the hometown for many celebrities from the Hollywood, right? That's the popularity first. There are other popularities also. But you know, when you are having so much of celebrities located in the one place like Los Angeles, the issue is somewhere else. The municipality, faces so much of challenges every day. One of the important aspects is about to provide the fresh water, drinking potable water through the pipelines to every households. There was a shortage of providing the potable water to different households, and municipality by their own took a decision that there is a mono lake, and mono lake is a very good scenic beauty, and it has a good aquatic life as well. There is a shrimp called brown shrimp. Now this brown shrimp is very much sensitive towards the water level of the lake. If it goes down, the brown shrimp that is basically will be dying. It's aquatic life after all. But the municipal authorities did not venture in that. And the tributaries, what exactly you mean by tributaries? Also, perhaps environmental students can say that. Tributaries which basically supply the water to the main water body. So out of 4 tributaries, 2 tributaries in which the Los Angeles municipality, they started extracting water to supply the water to the Los Angeles people. Now the question is that while extracting the water from the 2 tributaries out of 4, the water level of the monolith was going down. And as I just said that the brown shrimps are very much sensitive towards the water level, so in fact they started dying in the water. When the environmentalist national ornament is basically NGO, like in India we have the non-governmental organization, so there is NGO called national ornament. They filed a case with California Supreme Court, and Supreme Court accepted it's a very serious issue that the municipality has done that. And remember, there was a debate between public versus general public. The municipality claimed that we are obligated to the public of Los Angeles, and national ornament claimed that the mono lake is not belonging to the only Los Angeles people, it belongs to the entire US. Based on that, decision was granted. And National Ornament ultimately won the case against the municipality in Los Angeles. So public trust doctrine means the first restriction which was being saved, that it's not only for the public use, it should be for the use of general public. So that was the indication which was being given. Now, we don't have much time, so I'm just quickly coming back to the very important aspect of Kamal Nath case. So there are a series of cases, as I said to the principal sir, like to supply this slide to you as well after the program, so that you can also be benefited from that aspect. Kamal Nath case basically relied on this aspect of what is called public versus general public. Now, if you take the forest land in Himachal Pradesh, where this, the span model was established. Now, lots of models basically coming from the US part. So, span model was an example of that, was being given a level of ecotourism. See, in the name of ecotourism, you should understand it's a more devastating to the forest or environment. Though it is named as ecotourism, but it's basically ecocide. So, we should not say always ecotourism is always good for environment. No, it is not true. So far, regarding ecotourism, no public interest litigation being filed before the writ courts like High Court or Supreme Court. Otherwise, you will find the real picture. Ecotourism, basically, it's ecocide. Otherwise, right? So maybe there are issues which are still pending for to be answered by the writ courts in India. Remember, we have NGT, right? What is an NGT? National Green Tribunal, right? But the only part is that National Green Tribunal is a consequence of a statute, and it is a schedule which consists of lots of legislation and environment. Beyond that, the concerned NGT cannot provide any award. So remember, NGT is a tribunal, is not a writ court. Regarding violation of fundamental right, you have to approach to only High Court and Supreme Court. Clear? Fine. So, but at least all whatever the legislative issues regarding Water Act, Air Act, Environment Protection Act, Forest Act, Wildlife Act, all these things settled by the NGT. But fundamental right violation means approach to only writ courts in India. So this is the Indian position so far. But now in Indian position, what happened? For example, the forest land, one portion of forest land was being given in the name of span model for 99 years of lease. But question is, whether that land was transferred by the state government, answer is yes. Whether that transfer was done only after getting prior approval from central government, answer is yes. Then where is the flaw? If you consider that everything has been done by the provisions of law, then why M.C. Mehta's petition should be accepted? But M.C. Mehta's petition was accepted because of the fact that this Professor Josephel Sachs' opinion that there are certain properties which should not be used for public only, but for the general public. Now, even if there is law, so remember, there is another important case will come, Reliance versus Reliance Industries case of 2010. But if you go back with that aspect, in Kamal Nath case, there was a specific clarification was being done that even if the Forest Conservation Act 1980 Section 2 Clause 2 and 3 authorizes the state government to transfer the forest land for non-forest purposes, but Supreme Court can go beyond the provisions of law for the purpose of establishing that the forest property belongs to the general public in India and cannot be eliminated or transferred to the private individuals. And Supreme Court directed in that judgment that government should immediately struck down that provision from section 2. So what happens then finally? That in why we are saying Kamal Nath is very important here? Because today we are observing National Environment Day. And this, when we speak about the World Environment Day, so this was an example of national environment on that day, which year? 1996. Because on that day, justice was being delivered for the purpose of protecting and preserving the natural resources in India, particularly forest. So World Environment Day has its own, so for the beauty, that today we are discussing the Kamal Nath case. Why? Because the Supreme Court for the first time went beyond the provisions of law. See, what we are studying nowadays in class, you are a student, I was a student, I'm still a student, I still learn. What we generally go, that fact of the case, provisions of law. That's all our life is. And remember, till we survive, we have to, as a lawyer, we have to just go with, or judges has a go with, and as a teacher also, we have to just find out the provisions of law, provisions of law, right? That is the part of life, we have to accept that. But the Supreme Court, what Supreme Court has done that a part of the provision of a particular Forest Conservation Act that was taken up, is struck down, and said that this particular provision is not a good example of law. If you support, if you respect publisher's doctrine, Section 2, Clause 2 and 3 obviously cannot be taken into account for the purpose of preserving forest resources in India. So this is something, another part is that, see, we are always, having the mind or mindset of that how we can avoid the obligation of law. One of the important examples stands here with this MI Builders case. Anybody studied MI Builders case yet from the environmental students? No hands means not studied, fine. Alright, so this case is a unique one. We have always tendency to exploit laws or find out loopholes in law. This is an example of that. After accepting public trust, this another round of cases came up before the Supreme Court. And if you find it, here you won't find the traces of M.C. Mehta. For example, you are not transferring forest land, but you are giving the underground portion of forest for the purpose of construction of central parking area and a small resort. Which place is this now? Underground portion of forest. So you are not affecting forest at all. You are not at all affecting wildlife at all. But the only issue is that you are basically have taken the underground portion of a small portion of forest land, given in the hand of a private owner, construct a central parking area, construct a small resort underground, and also establish state-of-the-art pollution control system. So basically, it's eco-friendly. It's ecotourism. Will you allow that? As a judge, will you allow that now after this Kamal Nath case in India? Because you are not affecting forest land, you are not affecting wildlife, you are also not taking away the status of national parks or sanctuaries. So, when you speak about protected forest or reserve forest, they are the part of Indian Forest 1927. When you're speaking about the national parks and sanctuaries, they are the part of the Wildlife Protection 1972, remember. So there are 4 terms: reserve forest, protected forest, national parks and sanctuaries. But they are dealing with 2 different legislations in India. All are connected with the forest reserves only. So coming back to that aspect, will you allow that as a judge? The answer is no, because of M.I. Builders case. Now we go back with jurisprudence. Jurisprudence perhaps you've studied all, Justinian Code. In jurisprudence, see, again I'm giving you, don't fear, I'm not going to ask any question, just a matter of discussion only, right? So feel free to participate. In jurisprudence, when you go with the concept of property, so the ownership of property is not only piece of land, but the sky above and so as below, that means ground. The only exception nowadays we have found from 2012 is about groundwater. You can't claim ownership, exclusive ownership on groundwater, right? Please remember that. Nowadays you can't claim ownership on groundwater, even if you're owning a piece of land. You must have right to fair use, but you can't construct. You'll find nowadays in different households or some places, they are going for the distilled, mineral water in the industries with the groundwater. The municipality can never grant such trades. But it is being practiced nowadays in Kolkata as well. This is one of the important aspects which, while coming down here, I found one of the observation not compatible with the World Environment Day. So I'm waiting for those aspects from the any one of you who really rather came across of any incidents which is not compatible with the World Environment Day, specifically for today. So just I'm going to wrap up my discussion here. Quickly, I'm ending now with this public doctrine. So what ultimately so far being given, the answer is if you go with the ownership, if public is the owner, if general public is the owner of such forest land, how come you can give the underground portion of that land in the name of private owner. So, MI Builders case is the exactly deadline for that. Now, coming back to another important approach, there's something is very important aspect. With this, I'll end your discussion. Reliance Industries case. Article 297. Anybody knows about what is that? Article 297. If you go with 297 and with Reliance Industries case, you have to go back with the international law. Anybody has studied international law so far in this all? Just showing the hand will be more than enough. Okay, fine. So international law says about maritime zone at the same time, 12 nautical miles and 200 nautical miles. If India suppose finds a huge chunk of fossil fuel in the Arabian Sea, but within 200 nautical miles, in the Bay of Bengal within 12 nautical miles, huge chunk of the fossil fuels, that is called the crude oil. Which one will be belonging to India exclusively, within 12 nautical miles or 200 nautical miles? So if you go with that, so Reliance Industries case is the answer for that, right? So Article 297 gives you the indication. It's not only 12 nautical miles, it goes up to, because exclusive economic zone when you speak about, so economic resource of the country which belongs up to 200 nautical miles. So if crude oil is being found, so obviously India will have stake on that and can extract the water. It's not in the high seas, but I'm just quickly coming back with one of the previous slides. It will be easy for you to understand from that particular perspective. This I was speaking about Article 297, you can find it out here. So, the Supreme Court in the year 2010 finally proposed that Article 297 is the example of public trust doctrine in India. Excuse me. So, from that particular perspective, now we say that the constitutional provision in India also promotes, public trust doctrine in India. So with this, I end here my discussion on the public trust, but now I am open to take any questions from your end. But before that, anybody of yours would like to say that which particular incident you come across today which is not compatible with the World Environment Day? Anybody? Yeah, okay.
I think some of these building of roads. When I was coming from Bardhan today and I watched that there were many trees over there. Okay, nearly about 3 years ago. But now, just because roads are being constructed, therefore I was watching that how the trees were being cut down, and this has happened more than 1,000 kilometers.
Many thanks for this observation. What's your name, please?
So my name is Syed Misbahul Islam.
Syed?
Misbahul Islam.
Okay. So, Mr. Islam, should I say? Okay. Okay, Misbahul. Okay, thank you for raising this issue. When we are speaking about, like, perhaps he has given a very good example, like, the cutting down of trees are being found rampantly nowadays. So, thanks for bringing this important issue that you have felt it, like today's World Environment, but you're finding that, like the depletion of groundwater, you're finding depletion of forest resources or the plant resources in India. Absolutely, we will take this move. So, this particular move obviously is a serious aspects because, when today we see like plant a tree to save the planet, his example is exactly we have found like there are lots of depletion of trees and plants. That is one of the important issues. So thank you for bringing this important aspect. So there will be a possibility of filing a PI before the High Court. So obviously you can mention this aspect. We can take this matter forward for that approach. Thank you again once more. Yes, the next and last one.
Sir, Prem Prakash for 8th semester.
Would like to just reveal your name this time.
Sir, Prem Prakash for 8th semester.
Yeah, thank you, Prem. Please go ahead.
Sir, we are celebrating the environment, and now we are at the same time have all body have plastic bottle in our bag, including everyone in this entire platform. So how can we overcome from this type of problems? At the same time, we give the examples of the beat the plastic and save the earth, save the environment. we are giving a slogan like this. And now we all have the plastic bottle. So how can we conclude and how can we overcome from such type of problem?
Okay, many thanks, Prem, for raising this very common but at the same time unique question. Thank you. Please have a seat. Okay, so now like this is a very common question to that aspect about plastic bottles. Say we have plastic rules from 1998 onwards. We are finding these issues. Recently being revised in 2016. So if you go back with the millimicrons, so we are saying like it should be nowadays. Earlier it was 50 millimicron, and now it has gone to more than 120 millimicrons. Why so? The plastics are not banned, but regarding its use and thereafter throwing it away. How you're throwing it away? Now this is something that's very important. That's why what we say that basically ban your campus or in your daily life single-use plastic. But it's very easy to say. It's very difficult to observe. Now what is called single-use plastic? Means you take the water from a bottle and then throw it away. That creates a trash. And when you are speaking about the plastics, ultimately where it is found, it is being found in the deep Pacific Ocean. So all global plastics are ultimately going somewhere and mixing with the deep Pacific Ocean. And aquatic life is at risk now. So these plastics are not native for the deep Pacific Ocean reach, right? But that is exactly the aspect. So it is about our mindset. What Prem has asked, it's just answering is that mindset, like how we are going to, this nurture our daily life. We always say like, just stop using single-use plastic. Go ahead. If you want to keep the bag and you want to reuse it, keep it. Unless you're creating a trash, you're not creating any problem. Unless you're creating a garbage, you're not creating any problem. So single-use plastic means what? Which are meant for single-use, means you use and then throw. That creates problem. So it's a part of, like, if you really would like to use it, and remember that you can't use certain items permanently. Ultimately, there will be, death cycle. When we speak about, for everything there is a death cycle. So then what happens? You are throwing every day the single-use plastics. You are creating basically a heap of the plastics, which creates problem for the environment. If you are reusing it always, then absolutely perfect. You go ahead with that, because then what happens? The creating ratio of the trash from the single-use plastics become less. So that is the answer, that it is a mindset, because remember, we have heard from many jurists in India that you can make so many laws, but hardly those provisions will be followed. You can make many laws, and that's why so many cases are being filed before the courts. The only answer is that you make a movement. Unless you make a movement for that, merely bringing law will not give any help. So that's what exactly asks, like the need of the hour so far suggests. Yes, there is another question, right?
Sir, I am Shahriyar Sajid from 6th semester. Is liberating the public trust doctrine is bad for public? If it is, then why?
Okay, once more, can you just repeat your name, please?
Shahriyar Sajid.
Mr. Sajid, right? Okay, so your question is regarding the public trust doctrine. Is it good or bad for the public? See, Mr. Sajid, again, thanks for asking this question first of all. Let me quickly come back. See, public trust doctrine is meant for preserving those properties, the common properties, which play a vital role for the purpose of our ecosystem. Vital role means lifeline, basically. So, for example, if you take the running water of the river, you can't expect that somebody will be owning a river. That is one. If you go for wildlife or forest, obviously you can't expect like somebody is owning such particular, the property, individual ownership. So public trust doctrine, in a way, if you go with the general public property, it is always good. But if you restrict it only for public, it is not good. what we have seen from the national domain case, at the same time from the Kamal Nath case in India. Just to end, unlike observation, what Sajid has raised, you have, like Konkan Railway, most of you have already heard about that. When the Konkan Railway was under this project was being undertaken, lots of forests got devastated. Now the question is that, whether was it not possible for the government of India and the respective state governments, so one means you'll find Maharashtra, then Goa, then you'll find Karnataka, you'll find even including Kerala, because the project was to be extended. So along with these 4 states and the central government could have really, provided the sufficient money for the purpose of establishing flyovers. Because flyovers, then what happens, you are destructing forest and in very less amount. If you go with these Hawaiian islands in Honolulu in particular, you will find like this is called like city of flyovers. You will find like in deep dense forest the flyovers are there, and you are basically only those portions being occupied where you will find pillars of the flyovers are available. Otherwise, its scenic is actually not being disturbed at all. So Konkan Railway, Mr. Sajid, your question's answer would be Konkan Railway's case was the example where, though it was being considered for general public, but devastation to the forest could have been controlled had this been flyover project rather than cutting down and establishing the railway tracks over the surface of the earth. That is my observation. Yeah, another question, please.
My name is Mir Farhad from 6th semester.
I'm not clear about your name, please.
Mir Farhad.
Okay, Mir, Mr. Mir. Okay.
My question is to get rid of the crisis of climate, nature, or environment, or to stop the free exploitation of life nature. The demand of tax the corporate from various movement of environmental movement. So how far this effective? This solution is effective, and what is your opinion?
Okay, thank you for asking this
Excuse me, sir.
question.
Before you answer, due to shortage of time, this will be the last question we'll be able
Okay, thank you so much for reminding me again once more. So, Mr. Mir, just to quickly answer your question about like how to get rid of environmental degradation and the side effects of the climate change, like so far. Yes, the right moment is about the movement. What we say, like you can bring so many policies, you can bring so many laws, but unless it is we the individuals are not making the movement that this is something which we have to accept and we have to set trends to the society. It's not for us only, for the future generation as well. So these changes we cannot bring. For example, you have how many of you know already that there is a national environment policy of basically 2006? It's a national environment policy. There is no movement in India at all, and policy are always given to state government to work upon. Similarly, when you have the national population policy, how the particular movement so far has been made in India. So this is something, aspect of what is to be considered as the movement. So now the aspect why we see some movement, because there are out of 100 will find 10, 15, maximum 25 persons will following law. Others are having a dilemma: should we follow, should not? But remaining 50%, they are hardly bothered about what law is or policy is. So for them, you need movement. So it's not for like movement for 100% people, because there are persons who are conscious about laws and policies, they will take care of it. There are people who are a bit confused, but remaining 50%, when they are coming under movement and taking steps, those confused people also will be following their cue. So that is exactly the aspect. So the movement when being said about, it is basically for those who are not at all in fashion of following the like the mandates for how to preserve the environment, not only for them but for the future generations to come. But I'm sorry, I'm ending here the discussion because of the paucity of time, and I will further take the questions through email. I'm sending my email ID to my principal, to this principal, so he can definitely provide you the email. You can raise questions and we'll take the answers from that particular perspective. Again, thank you so much, Mir. Thank you so much.
Thank you, sir. Your years of research, your depth of understanding of environmental laws, and your ability to present the subject in such an interesting manner produced no doubtably one of the most memorable afterwards for us. We extend our warm welcome and also a lot of gratitude for your valuable contributions. So since